A woman called our office on a Tuesday afternoon. Her mother had just been diagnosed with early stage Alzheimer's. She had spent the whole weekend at her mother's house, going through the mail, looking for legal papers, trying to find anything. Unfortunately, there was nothing. No power of attorney, no healthcare directive, no will, no trust. Just a paid off home, a savings account with $280,000 in it, and a daughter with no legal authority to do a single thing. If you're watching this video right now, there's a good chance you're in a similar situation. And I want to give you a straight answer, not a lecture, not legal jargon, just exactly what you need to know and what you need to do. Hi, I'm Chuck Roulette. I'm an estate and elder law attorney licensed in both Florida and Minnesota. And I've been helping families with exactly this kind of situation for nearly 30 years. Now, before we begin, if you find this video helpful, hit subscribe. I put out new videos every week on how to protect your family's home and savings. If you have a question, post it in the comments below and I may answer it in an upcoming video. And if you stay until the end, I'll share some resources where you can discover more. So here's the first thing you need to understand, and this is critical. A dementia diagnosis does not automatically disqualify someone from signing legal documents. The question, rather, is whether your parent currently has what we call legal capacity, meaning they understand what they're signing, who their family is, and what they own. A lot of people in early stage dementia still have that capacity. But here's the problem. Once that window closes, once your parent no longer has legal capacity, they cannot sign a power of attorney, a trust, or any other legal document. And at that point, the only way to get legal authority over their affairs is to go to a court. And that process, called guardianship or conservatorship, can take 6 to 12 months and cost $10,000 to $15,000 or more. I once had a client, let's call him Robert, who waited 6 months after his wife's diagnosis to call us. Unfortunately, by the time he did, she could no longer pass a capacity test. He ended up spending over $7,000 in 6 months in court with another law firm to get the legal authority he needed. Had he called us when she was first diagnosed, we could have handled everything in a few weeks and for less money. So what do you do first? Well, you get 3 documents in place as soon as possible. Number 1 is a durable financial power of attorney. This gives you the legal authority to manage your parents' money, pay their bills, deal with their bank accounts, and handle their property. Without it, you have no legal right to touch their finances. None, even as their adult child. And I want to emphasize that word, durable. A regular power of attorney becomes invalid when someone becomes incapacitated. A durable power of attorney stays valid. For a parent with dementia, you need the durable version. Number 2, you need a healthcare power of attorney. This gives someone the legal authority to make medical decisions when your parent can't make them anymore. Number 3, a living will or advanced healthcare directive. This is your parent's written record of what they want for end-of-life care. Do they want aggressive treatment? Comfort care? What does a natural death look like to them? I've watched close families completely fall apart because there was no document and the siblings couldn't agree. A living will helps prevent that. Now, maybe you're thinking, Chuck, my parents have a will, we're covered. I hear this all the time. And I have to tell you, a will is better than nothing, but is far from a complete plan. Here's something that surprises almost everyone. A will does not avoid probate. A will almost actually guarantees probate. Probate is the court process that validates the will and oversees distributing the assets. It's public. Anyone can look up what your parent owned and who got it. It's slow. It can take a year or two, and it's potentially expensive. In Florida, even on a modest estate with, say, a $400,000 home and a couple $100,000 in savings, attorney's fees alone can exceed $10,000. Minnesota is similar. Now, a revocable living trust is often a better alternative. It avoids probate. It's private, and it works while your parent is alive and incapacitated. But here's the critical thing even many attorneys miss. A revocable living trust does not protect your parents' homes and savings from long-term care. Let me repeat that. A revocable living trust does not, by itself, protect your parents' home and savings from long-term care costs. And that's because Medicaid counts the assets in a revocable trust exactly as if they were sitting in a bank account. So even if your parents have a trust, there's additional planning that still needs to be done. So let me give you a sense of what we're actually protecting against. At the time of this video, a private room in a nursing home or memory care facility can cost over $150,000 a year in both Florida and Minnesota. and the average person with Alzheimer's lives 8 to 10 years after diagnosis, with the last 3 to 5 years requiring often full-time care. So do the math. At $150,000 a year for 5 years, that's $750,000. That's most people's entire life savings. And here's another thing you really need to know. Medicare does not cover this. Medicare is for short-term skilled care after a hospital stay. It stops after 100 days. For long-term dementia care, Medicare covers almost nothing. Medicaid will pay for long-term care, but it comes with strict rules, and this is where most families make a catastrophic mistake. When your parent applies for Medicaid, the government looks back at every financial transaction they made in the previous 60 months, 5 full years. So any gifts or transfers made for less than fair market value during that window can result in a penalty period, a period of time where your parent is not eligible for benefits even if they otherwise qualify. One family, mom had dementia. The kids gave away $200,000 to try to protect it, thinking they were being smart. Unfortunately, 3 years later, mom needed full memory care. Medicaid looked back, found the transfers, and imposed a penalty of over 22 months. The family had to come up with $180,000 in private pay costs for care during that penalty period. The money was already gone. Had they worked with an elder law attorney first, we could have protected those assets legally without triggering any penalty at all. Now, here's the good news. Even after a dementia diagnosis, even when things feel late, there are often still powerful legal tools available. One of the most effective is called a Medicaid Asset Protection Trust. This is a specialized, irrevocable trust authorized under federal law, designed to hold assets outside of your parents' estate for Medicaid purposes. Assets transferred into this trust are generally not counted toward Medicaid eligibility, but only after the 5-year look-back clock is fully run. And this is exactly why timing matters so much. The sooner the trust is established, the sooner the clock starts. If your parent is married, there are additional protections for the healthy spouse. Federal law protects what's known as a community spouse or the healthy spouse from being left completely impoverished. And even in situations where a parent can no longer sign documents, where it really does feel too late, there are still steps an elder law attorney can sometimes take to protect what's left. So the families who call us early almost always have more options than they expected. The families who wait, unfortunately, they rarely do. So let me give you a quick action plan, the things you need to do right now. 1, call an elder law attorney this week, not next month, this week. 2, ask your parent's doctor, does my parent currently have the legal capacity to sign documents? You need to know. 3, if capacity exists, get powers of attorney and healthcare documents in place immediately. 4, do not move, transfer, or give away any of your parents' assets until you've spoken with an attorney. This is one of the most common ways families accidentally trigger a Medicaid penalty. 5, if your parent already has a will or trust, bring those documents in for review. As we discussed, a revocable trust alone is not enough. I watched my grandparents lose everything to a nursing home, their homes, their savings, and ultimately their dignity, because at the time, Minnesota was not following federal law. My grandfather, a World War II veteran, wept when he learned everything, including the small home he inherited from his brother, was gone. Thankfully, Minnesota has now been forced to follow federal law. Florida has been following federal law for many years. And that experience shaped the way I practice law. In nearly 30 years, I have helped hundreds of families protect their homes, their savings, and their peace of mind, even when the diagnosis had already arrived. I've also sat across from families where it was too late to do everything we could have done earlier. And I don't want that to be your family's story. If your parent has just been diagnosed, or if you've been watching them decline and you've been putting this off, please don't wait any longer. The window may still be open, but it won't be open forever. I've put together a free guide called Save Our Home. It walks you through how families can protect their home and savings from long-term care and nursing home costs. The link to download it is in the description below. Share it with your siblings. Share it with your parents. It's completely free. I also have an exclusive online masterclass where I reveal strategies I use with my private clients and their families to help them protect their home and life savings. You can sign up and join us by clicking the link in the description below. And if you're ready to have a real conversation about your family's specific situation, visit us at roulettelaw.com. Thank you for watching, and if this video helped you, please share it. There are a lot of families out there who need to see it. I look forward to seeing you in an upcoming video and the masterclass. Be well.